Let's take a quick look at Vic Mignogna's first point of error in his appeal brief, alleging that the dismissal of the defamation claims against the four defendants, Monica Rial, Ron Toye, Funimation, and Jamie Markey, was improper. Stick with me. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. And today we're going to cover real quick one of these quick hit legal infusions, if you will. Cover your orifices. We're going to cover this first point of error in Vic's appeal brief, which is the dismissal of the defamation claims against all four defendants. I've been trying to figure out how to exactly do this, and I think I've got a good way to summarize it without going through the whole argument. So let's do that. If you like these quick videos, these legal infusions, whatever you want to call them, please like, share, subscribe, all of that stuff that YouTube wants me to ask you to do. I mean, if you like this content, come do it. Also, come check out a live stream if you have the time and if that's the format you like as well. They're typically every weekday at 11 p.m. Central, including today, which is Monday. So let's take a look at this, though, now that that's out of the way. All right. So here we have, this is the first point of error addressed in the appellant's brief. If you saw my other summary video, it gave kind of an overarching view of the arguments that they're going to be presenting. Now we're going to take a quick look, and I'm going to offer some of my opinions of what their sort of strategy is. I'm not going to just read you the document here. You can go through the live streams, and we do read every single stinking word and line of the document, which is tedious, but that's the legal work that you have to do. This is just a quick hit of the strategy and kind of a summary of the topic where I think it exists. So the trial court's dismissing appellant's claims against appellees for defamation is reversible error, as stated. That's the first point. And they lay out the summary in the first part of the paragraphs here. And with it, they say Vic met his burden to establish a prima facie case for each essential elements of his defamation claim against each appellee by clear and specific evidence. All right. This is the standard required by the TCPA to, by clear and specific evidence, make a prima facie case for each essential element of a particular claim. In this case, it's defamation. All right. They further go on to identify what that means. He was required to produce the minimum quantum of evidence supporting a rational inference that an appellee published a false statement that defamed him with the requisite degree of fault regarding the truth and damages. And that he incurred damages is what they're saying. All right. This is the key to this entire argument, this prima facie case. And what they're going to do is try to make Judge Chupp's hearing and his handling of the documents a referendum on what is exactly a prima facie case. Prima facie is a low bar to overcome. It typically means that you just have to provide enough allegations so that the defense is aware of what you're actually suing over, what the lawsuit is about. That tends to require some sort of facts about what statements were made when in defamation, what statements were made, when the statements were made, who they were made by, who they were made to, if it was like a private conversation, right? You have to allege some level of fact to say that this happened and this caused that result. Now, the court, at a prima facie showing, or for a prima facie analysis, they have to go ahead and decide whether or not there are sufficient facts present to give appropriate notice to the defense and to tell the court and the defendants what actually we're going to be talking about. Do you have a claim? Like if I just say someone said something about me sometime and it caused me damage later, that doesn't help anybody. They don't even know what they're supposed to be defending against, right? Because presumably they've said other things in their life than just what I think they said. So I haven't identified what statements we're talking about. I haven't identified that those statements cause damages. Now, this doesn't need to lay out an entire case. It doesn't need to prove anything in the case. It's actually, for the purposes of prima facie analysis, it's all taken as true. It's all taken as true. It's read in favor of the plaintiff bringing suit. Like I said, this is not the stage in which you have to prove out the elements of the case at pre-trial. That goes against the very notion of the trial system and of the idea of having a fact finder in a judge or a jury. We want just a basic showing that says, okay, you're going to be defending against this type of thing or this specific thing, and they have enough facts to say that, yeah, we think that what you did caused the damage, right? That's it. That's a basic prima facie case. Now, the TCPA further imposes a little bit more of a burden with this clear and specific evidence. A basic prima facie case is just kind of enough facts to make the allegations known and understood by the court and the defendants, right? But this clear and specific evidence of each essential element of the claim is a little bit, it's a slightly elevated burden. That's where you have to link some allegations, some fact statements, and hopefully some direct evidence or some circumstantial evidence. Now, direct evidence is like, here's this thing that happened, right? Here's direct evidence. A direct evidence of a lie would be someone saying they lied, right? I lied about this thing. There you go. That's direct evidence that they did lie about the thing. Circumstantial evidence would be if they said one thing and then acted contrary to what they said, almost like a hypocrisy. It would show that it would give an inference that they were lying. Both of them are acceptable for the TCPA. Both direct and circumstantial evidence would be acceptable. So what their job is to provide clear and specific instances of those for each of the 4 elements of defamation in this case. And they have to do that for each of the defendants. That's what they go on to lay out by talking about the tweets that they made, how they were lies, how they should have known they were lies because Vic said, this is all false. I didn't do any of this, how they failed to retract. All of that stuff is laid out in the subsequent section. I don't want to go through that on this short video. It would be just me reading it. But the strategy behind this is to really hammer home the idea of what is a prima facie showing. That's what they're going for here, in my opinion. And that is to make the appeals court issue a decision about what prima facie actually means. How high of a bar is it? Most people would understand prima facie to be a low bar. What they're going to do here, especially if they get oral argument, would be my guess, or perhaps in their response brief, they're going to lay out that all of the things that the defense is likely to raise in their response, all of this goes against the idea of prima facie and goes more towards trying the case out and having a preponderance of the evidence standard, but at a pre-trial stage. That's not what the TCPA says. That's not what it's for. And that is a place where the appeals courts have often overturned the district court, is this misunderstanding of what prima facie showing actually means. And I'm not just saying that the district court always gets it wrong in this way. They often get it wrong in the other way. Because prima facie goes kind of against what a judge is inclined to do. A judge wants to solve the problem. They want to find the facts that actually occurred and determine the winner. But prima facie doesn't do that. You have to make all of these assumptions in the favor of the plaintiff. So they're going to try and make this case a referendum from the appeals court on what prima facie actually means. This is a double-edged sword? Not really. It's not a double-edged sword. It's a two-pronged attack, right? You either get the appeals court to remind the district court that the prima facie burden is really significantly low. It's only there to throw out completely meritless claims, and here we have a whole bunch of merit. It's also this idea that the defense is going to raise procedural issues as the failings of the case, rather than attacking the actual merits of the claims. They're going to say, well, they failed to bring this because the second amended petition shouldn't be included and these unsworn declarations shouldn't be included. Well, why shouldn't they? Well, because they're devastating to our case, so they shouldn't be included. So they're going to make this, again, it's a referendum on what prima facie is. The second prong of that attack, the first prong is getting the appeals court to lay out just how low of a burden prima facie is and to question whether or not a perceived procedural defect or a defect in form on some of the evidence is sufficiently deficient to prejudice a plaintiff out of his own claims, even though he brought the argument would be he brought the stuff, the defense just objected to how it was being entered, therefore it didn't exist, but it's right there looking at you. And even Chupp acknowledges this in his order. So the second prong of the attack is if the appeals court says that prima facie is anything less than what prima facie is, it sets up a potential further appeal to the Supreme Court to clarify. Because prima facie, we have an understanding of what it means, and the TCPA and how it's sometimes read can definitely go against that. I mean, heck, the clear and specific evidence requirement in the TCPA almost by itself runs contrary to what a prima facie showing would normally be. It puts a higher burden on the plaintiff while foreclosing the plaintiff's ability to actually engage in discovery, which you would normally have when you're trying to gather evidence. You have the discovery tools available. So what they're, again, my opinion, what they're trying to do here is really make this case a referendum on what a prima facie showing is, because it sets up the appeals court to render a decision that says, yeah, I mean, all he has to do is show us what they said, why it hurt him, that it was wrong, and that it caused him damage. Like, that's all he has to do. They haven't denied any of this. He did include tweets and allegations of statements that were made in all of these different places. That's all in the pleadings. It's in their responsive pleadings. It's in the motion documents back and forth. It's in the attachments of both party sides. And that's excluding the second amended petition that's at issue here. It's all there. He made all of these things. There's nothing to say that they didn't make these statements, and they don't even really contest that he suffered damages. They only contest that the damages were caused by them. Well, that's a fact question, not a prima facie question. So again, this is the summary of this appeals point on defamation. What is a prima facie showing of defamation? What does it actually look like? Put it down on paper, and then the idea that they have is that either the appeals court will realize that the bar is really low and they met that burden, or they'll set up something different that'll have to go up to the Supreme Court. So hope you guys found this informative and sort of thought-provoking. Again, you can come to the live streams and we go through every single word of the document. Here I just wanted to really lay out what I think the meat of their focus is. So hopefully you enjoy it and keep watching these videos, share them and all of that stuff. We'll talk to you soon. Have a good day. Peace. Peace.